and I'm so glad everyone has joined us today with the National Council of Juvenile and Family Court Judges, and I want to give you a little bit of an overview on the project itself. We are a national judicial membership organization, and so we have partnered along with Break the Cycle, the leading national nonprofit organization, working to provide comprehensive dating abuse programs and Futures Without Violence, a national victim advocacy and violence prevention organization, along with the Office of Violence Against Women, to implement the Teen Dating Violence Judicial Training and Technical Assistance Project. That's what is supporting this webinar today. The goal of this project is to increase the capacity of judges and court personnel to intervene effectively in teen dating violence. So I am going to go ahead and introduce our facilitators today. Today we have the Honorable Marshall Murray. Marshall Murray currently serves in the Civil Probate Court assignment in Milwaukee County, Wisconsin. Judge Murray has lectured extensively throughout the nation on domestic violence. He is currently a lecturer and board member of the National Training Center on Domestic Violence and Sexual Assault in Austin, Texas. Judge Murray is a faculty member of the National Judicial Institute on Domestic Violence, and also he was the program administrator for the United States Youth Soccer Region 2 Boys and Girls Olympic Development Program. He graduated from Williams College in Williamstown, Massachusetts, with a BA in Political Science and attended his JD in June 1986 from New England School of Law in Boston, Massachusetts. Welcome, Judge Murray. And we also have Marta Barrison. She is the Legal and Policy Director for Break the Cycle, a leading national nonprofit organization in the U.S. providing comprehensive dating abuse programs exclusively for young people ages 12 to 24. From the classroom to the courtroom, to the floor of Congress, Break the Cycle works every day to give young people and those who care about them the tools they need to build healthy relationships and create a culture without abuse. Marta is Break the Cycle's lead policy expert on federal and local policies that impact young people related to stalking, domestic violence, dating violence, and sexual assault. She also supplies the vision for BTC's comprehensive legal services. Marta is a lawyer with more than 20 years of experience in poverty law and in public policy. Welcome. Welcome, Marta. Welcome, Judge Murray.
Welcome, and thank you, everyone, for joining us this morning. It could be afternoon where you are. It's afternoon where I am here in the Midwest. But we're glad that you could join us for this webinar today. And I'm glad to be here with Marta. Marta's the expert here. I'm here to support her and the information that she's going to share with you. But hopefully I'll have something to share with you as well. So again, thank you for joining us today. What we're going to start out with is giving you an idea of what we're going to be doing today. We'll have our objectives that we'll be talking about in a moment. That's slide number 2 we're focusing on right now. We'll have some introductions by both myself and Marta, brief introductions because you learned so much about us early on in this presentation. We'll be focusing on Teen Dating Violence 101. Marta will be presenting information about that. Then we'll talk about what you know about your laws regarding young people seeking protective orders in your jurisdictions. I'll be working with you on that. And then we'll talk about how do you actually set up effective representation for youth victims that are seeking protective orders. So, as of today, our objectives are as follows. As a result of this training, you'll be better able to define teen dating violence and understand its dynamics. You'll be better able to distinguish how relationship violence affects young people differently than adults. You'll be better able to identify fundamental legal considerations when protection orders involve minors. And you'll be better able to identify options for effective protection orders in teen dating violence cases. Our mission today is for Marta and I to, and I'm going to, please call me by my first name as well. but Marta, who's the Legal and Policy Director for Breaking the Cycle and Advocates for Young Survivors. I'm going to turn it over to her. She'll be talking about our mission today, and I'll come back and talk to you in a few moments. Marta?
Thank you, Judge Murray. It's really wonderful to be here, and I just wanted to add to what Judge Murray said and just mention that teenagers and other young victims of dating violence may face several challenges when seeking protection orders to end abuse, and while all 50 states, territories, and many Indian tribes make protection orders available to adult victims of domestic violence, they've been slower to allow the issuance of similar protections to minor victims of dating violence. So legal professionals are really uniquely situated to assist these young victims, and that's why we're here today to lead a discussion about that. And I'm very happy to be here. As was already said, I'm the Legal and Policy Director for Break the Cycle, and I won't go over again what Break the Cycle does because that was covered in the beginning. But we do at Break the Cycle believe that everyone has the right to a safe and healthy relationship, and I'll just mention that we're a national nonprofit with legal services for young people ages 12 to 24 only in our D.C. office, but we also have offices in Los Angeles, California, and in Austin, Texas. Our work covers several areas. As I mentioned, in D.C., we provide free comprehensive legal services to young survivors of dating violence, domestic violence, stalking, and sexual assault. This includes assisting them with civil protection orders and related family law matters, handling Title IX cases for them, as well as criminal case advocacy. And we also advocate through our policy and legal services program for changes to federal and local laws that impact young survivors. Nationally, through our leadership and engagement program, we educate young people and engage young people in dialogue and activism around teen dating violence, including our youth advisory board called the Let's Be Real movement. And through our capacity building program, we provide education and support to professionals and other caring adults who are serving youth nationwide, such as teachers in schools.
So we're now going to conduct our first poll of this session, and we'd like to get some information from you. So we're going to take a quick poll to get a sense of who is on the webinar. So if you could answer the following questions. What is your position, your job, and your role? So we can get a sense of who's with us today. Great, the numbers look good. Keep coming. We have all 36 of you logged in? And it looks like we have at least 26 or 27 of you now. So we hope that everyone is here to learn. Even though this webinar is geared towards a judicial audience, we know that and we suspect that attorneys and advocates can benefit from this information as well in helping to craft proposed protection orders, and also court personnel can use it as helpful information to help craft and form a template protection orders and petitions. So we think this will be benefit to everyone as well as judges. Thank you for signing in. Let's now have a brief discussion. So in your practice, and whatever you do as a lawyer, as an advocate, as a judge, do you encounter teen dating violence in your current work? And if so, in what way do you do that? Now, you can put your answers in on the chat portion of the webinar. Let us know. I see some advocates here, attorneys. We have sexual assault cases, civil protection orders. Ruth has a number of them. Working with survivors. Great. Again, sexual assault cases popping up. All teens looking for TROs against partners and parents. We're going to be focusing mostly on teen dating violence and how they may get a TRO against their, I guess you would call them a partner, but not necessarily parents, but let's see how things go. Schools are getting protective orders for their students. In juvenile cases and battery cases, yes. So a lot of folks have a lot of experience in this area and knowledge about teen dating violence. We will stop periodically for discussion, so please feel free to add your thoughts to anything that we might say or that we bring to the table. Let me go back to my partner at this time and get out Teen Dating Violence 101.
Great, thanks, Judge Murray. And I also wanted to add that in addition to putting comments in the chat box, if you have questions along the way, we're happy to answer them. We'll ask for questions at the end, but we're also happy to answer questions along the way. So we're first going to talk about teen dating, what teen dating violence is, some common aspects of teen dating violence, and some special considerations when working with young survivors. So first, for a little bit of background and statistics. 1 in 3 teens experience some kind of abuse in their romantic relationships, including verbal and emotional abuse. Nearly 1 in 10 high school students have been physically hurt on purpose by someone they've dated. 75% of 7th graders, so these are 12-year-olds, have had a boyfriend or girlfriend at some point already. And 1 in 5 women and nearly 1 in 7 men who've experienced rape, physical violence, and or stalking by an intimate partner first experienced some form of intimate partner violence between the ages of 11 and 17. And it's also important to note that most abuse gets more severe over time. I think we all know that if we've worked in the domestic violence field. And for that reason, it's really clear how important it is to intervene early. So what do we mean when we talk about teen dating violence? Teen dating violence is a pattern of abusive or coercive behaviors used to maintain power and control over a current or former intimate partner. Of course, this isn't a legal definition, so those are going to vary from state to state and law to law, but it is a commonly accepted definition among advocates and service providers. There are also other terms that people use to refer to teen dating violence, such as teen dating abuse, domestic violence, adolescent relationship abuse, or intimate partner violence. As many of you already know, abuse can be physical, but it also can be verbal, emotional, digital, or technological, and we're going to talk specifically a little bit about that, sexual, and financial. And it can include threats, isolation, and intimidation. In an abusive relationship, the victim and abuser could be any sex or gender, male, female, transgender, or non-binary. Abuse can occur in relationships that are short-term or long-term, casual or serious, monogamous or polyamorous, gay or straight, and sexual or non-sexual. And abuse can also happen, of course, whether either partner is wealthy, middle class, or low income. For the purposes of our conversation, when we use the term youth, I just want to be clear, or adolescent, that we're talking about young people ages 11 to 17 as defined under VAWA. The upper limit of that ensures we're talking about the unique needs of young people who are minors, and the lower limit ensures we're talking about all young people who are dating and thus at risk of dating abuse. And that lower limit also matches up with VAWA's definition of youth. So practitioners should be sensitive to the unique influences on youth dating behavior and the obstacles that teens face in recognizing and seeking help for abusive relationships. Teens are often new to relationships and may have difficulty sorting through the many messages they receive every day from friends and family and the media about what those relationships should look like and how people should behave in romantic relationships. And adolescents, of course, are also really hardwired to be skeptical or even distrustful of adults. I have 2 teenage daughters, so I know that that's very true. And so we really need to recognize that when they reach out for help, that that's a really big step for them to take. And we should make sure that we respond accordingly. We at Break the Cycle I held actually a listening session last week with young people in DC about cyber abuse, and the common themes kept coming up about when we asked why or why not, why would you or would you not report cyber abuse to an adult like a teacher or a parent? And they were really clear that they fear that adults will be judgmental, that they'll blame them for what's occurred, that they won't actually solve the problem or understand what's going on. So it's really important for us as adults to take them seriously, to really take action, and to not blame them if we expect them to come forward. So there are similarities, several similarities between adult and youth dating behavior, such as the intensity of feelings and significance of the relationship. The patterns and cycles and escalation of abuse are similar. The types of abuse, as we just discussed, are very similar. And the difficulty in leaving the relationship and how challenging that feels to the victim. But despite the similarities, there's also many significant differences that are really important to keep in mind when you're working with young people. For example, while both teens and adults experience physical abuse, such as being pushed or punched or strangled, teens may experience physical acts of abuse masked as play fighting. Play fighting can be used by an abuser as an opportunity to sort of express physical dominance and create fear with immunity. Break the Cycle has successfully represented clients in CPO cases on the basis of play fighting. And actually in that listening session I was just talking about last week, there was a young teenage couple in that session, and I noticed this play fighting going on between them. And it was amazing to witness it just right in front of me. So it, obviously to them it seemed like acceptable behavior, but one of them was completely the aggressor in the situation, and like sort of, there's no other way to describe it than play fighting, like slapping the other one but doing it with a smile on their face, but it was kind of constant throughout the session. While both teens and adults experience sexual abuse, such as being forced to engage in sexual acts, teen victims are especially vulnerable, as we all know, to being peer pressured or to go further than they want. And finally, with regard to emotional and verbal abuse, such as threats, jealousy, and controlling behavior, teens are especially vulnerable to this type of abuse through the use of technology, because technology is so prevalent in the lives of young people. And this type of abuse often goes unseen by adults because it's not happening right in front of them. It's happening on devices. And I also learned in this listening session last week that young people feel that adults don't want to get involved, which I was kind of surprised about it. They see teachers being aware of cyber abuse or hearing students talking about it and not getting involved, either because they don't know how to get involved, or some of the teens feel that adults often feel that this is just bullying and it's gone on for years. That's what happened when I was a kid. It was just bullying, and they aren't really taking it as seriously as young people think they need to take it.
So thank you, Marta. That was a lot of information that you shared with us, and hopefully we can use that as we continue through this webinar process. One of the things we need to know, even though now that we know a little bit about the issue that's in front of us or that we see every day, we need to know our laws regarding minor survivors seeking protection orders. And even though we're going to be focusing on protection orders, this information that we're talking about could be applied to protection orders either in criminal and juvenile. We're going to focus on the civil arena and how youth or young folks or teens can get a protective order. And sometimes, and during this discussion, all of us, we need to keep in mind, we may be express it as this is an idea that you should do. We're not suggesting that at all, because every jurisdiction is different. But of course, the ideas and options and considerations that we talk about hopefully will help you to come up with an effective way of putting together effective orders that should always be crafted for an individual who's seeking help and protection under the law. So let's talk about this for a moment. I have some questions that I'd like you to think about and answer if you can. is there a minimum age in the petition for court for protection order in your jurisdiction? Who can and may petition the court? I know in Wisconsin, it depends on what type of protection order you're seeking. Is it a domestic abuse injunction? A teenager could not do that, but they could seek a child abuse injunction or an harassment injunction. Can a minor petition on their own behalf, or must a parent file the petition? In some jurisdictions, we see parents coming in trying to get an injunction on behalf of their child. What's happening in your jurisdiction? Can the child come in alone? If so, how does that work? Is the party represented by someone? In Wisconsin, if a minor comes in, the courts that have jurisdiction would be the juvenile courts, and a guardian ad litem is appointed for the minor seeking the protective order, and the respondent as well. What happens in your jurisdiction? And what types of abuse are covered that they can come in and ask for? How is it defined in your statutes? So I'm seeing some responses here. I hear from Stacy. The age of the minor does not need a parent or guardian of 16. Okay, so under 16 they need a parent or guardian. Stacy, is that correct? And we just put up our new poll. How familiar are you with your state laws regarding the minor's ability to petition? And let's see what the numbers show. We have the same 20 some, or hopefully more this time. Also, can a protection order be issued against a minor respondent? And what are the enforcement mechanisms and consequences for a minor who violates a protection order? Do you know the answer to these questions? Catherine says, you need to have someone who is 18 do the petition on behalf of the minor. Could that be an advocate, or does it have to be a parent? Dave Stewart says, I look up the regs before I write one. That's a good idea. Make sure that we can get into court and into the right court. Catherine wrote, I cannot be an advocate. We don't expect courts to be advocates, but to at least maybe make sure that people get the right advice. It could be an advocate in your court or outside your court that advises victims of abuse. It could be a friend or a parent. And Taylor says we have to refer anyone filing under 18 to social services. What happens at social services, Taylor? Is someone, is there an advocate there that helps them to write, to apply for a protective order? And are they harassment injunctions? Are they abuse injunctions? Are they restraining orders? What type of injunction are they seeking? So we received some answers, what the minimum age is. Do parents need to be involved? It doesn't look like they always have to be involved. Sometimes what we see in Wisconsin is a parent coming in and asking for an injunction, and even though we're not talking about that today, but an injunction against another parent or an adult. Here we're focusing on the victim being a teenager and asking for an injunction against another teenager respondent.
And I'll just add, Judge Murray, that in Washington, D.C., as long as you're 12 years old or older, I think we're one of the most progressive jurisdictions in this regard, you can file for a CPO without your parents' involvement or consent, as long as it's an intimate partner case.
Hey. So, do you feel that, or do you think that teens in your jurisdiction know what the options that are available to them?
In D.C., are you asking, Judge Murray? Or are you asking people to chat that?
Asking people to chat about that.
Okay.
No, but I'm trying to change. Thank you, Taylor.
And it's 12 in San Francisco, too. Okay. Is that SF San Francisco? Great.
So let's talk about what makes up an effective protection order for minors. We're going to discuss this and hopefully give you some assistance when you work with survivors of domestic violence, teen dating violence. And speaking on this point, we're going to look at it from the point of view of a judge in crafting a protective order, but also how you can help. If you're an advocate, if you're a lawyer, if you are a guardian ad litem, how can you help the victim to know what he or she wants when they're seeking this protective order? I'm going to turn this back over to my partner, Marta.
Thank you. So when crafting a protection order for a minor survivor, the most important advice I can give is to really think creatively. And it's almost hard to give advice about protection orders because, and I'm sure this is true for many of you who represent adults as well, because you do need to think so creatively, and it really varies from case to case what's needed. But we need to remember to treat each order individually and craft it to really respond to the client who's before us and their needs, their desires, and their preferences. Many jurisdictions give courts broad discretion to grant equitable remedies. For example, in D.C., in addition to having many possible protection order remedies listed in our statute, we also have sort of a catch-all provision that empowers the court to direct the respondent to perform or refrain from other actions as may be appropriate to the effective resolution of the matter. So that enables us to have a lot of latitude in crafting orders. And there might also be case law in your jurisdiction that gives the court's broad latitude in ordering equitable remedies and in crafting injunctions. So don't hesitate to customize remedies to fit a minor survivor situation. For example, where a respondent follows a petitioner on Twitter, an order not to contact the petitioner might be effective if it includes a provision ordering the respondent not to follow the petitioner on Twitter. Of course, that's also going to be easier to enforce in a contempt proceeding. So make sure that you craft an order that's specific enough to meet the needs of the petitioner, but not so specific to be ineffective if the petitioner changes schools, jobs, lockers, or schedules. I think this is something that is even more pertinent in the case of teens, and that's why I wanted to mention it here. Appropriately explicit and specific provisions can improve compliance and enforcement. For instance, include provisions that prohibit the use of social media like Twitter, Snapchat, or Instagram, or technology to contact or harass the petitioner either by the respondent or by proxy. Lots of times we've seen cases where someone will try to, will be ordered not to contact the petitioner through technology, but then they'll continue to be harassed by a third party, and it's really the respondent using somebody else's account or somebody else's phone, and that can create some tricky situations in court. So it's good to have that catch-all phrase. Many protection orders include a no contact or no communication provision, but highlighting social media can make the order clearer to the restrained party, prevent the restrained party from thinking there's a loophole when it comes to communication, and as I said, make a stronger case for contempt in a contempt proceeding. In D.C., our template civil protection order actually that's been published by the court reads that respondent shall not contact petitioner by telephone, in writing, by electronic or social media or in any other matter, either directly or indirectly through a third party. So that's very good language if people want to try to have that incorporated into orders. You can also include provisions on attendance at school clubs, houses of worship, youth organizations, sporting events, or after-school activities in which both the petitioner and the respondent may participate. And as you can see, many of the provisions that are effective for adult survivors can be used for young survivors as well with appropriate modifications. So just think about and look for creative ways to get the client the protection that she needs. And we're going to talk in a few slides from now about some more specific recommendations for orders as well as discuss some hypothetical cases. But I'm going to turn it over to Judge Murray for a minute.
Thank you, Marta. And Marta, you know what? I forgot to inform people that if they are intrigued by the information that we're sharing with them today and would like to know more, that November 5th through the 8th of 2017 in Phoenix, Arizona, there will be an Institute on Teen Dating Violence. That's November 5th through the 8th in Phoenix, Arizona. I'll remind everybody at the end, but I want to let them know, hey, you know, we can plan on going to this institute and learn a lot more and frankly having discussions with each other at these institutes. They're wonderful institutes to go to, so mark your calendar now, November 5th through the 8th of 2017. Let's talk about how judges and those who appear in front of judges can make sure that the parties in court know exactly what is going on. So it's important for the judges and those in the courts to be sure that both the petitioner and the respondent understand the provisions of the protection order. Now, they can do this by a colloquy with the voir dire with the respondent, and making sure that he or she understands the implications of this order by the court and what would happen if they violate the order. That's so important. Also, remember that this order is the victim's order and that the petitioner may decide at some point to ask that the order be modified, extended, or vacated. And we want to let them know that they can always come back to court, that the door is always open, and that they can come back to court, the victim can come back and ask for modifications, extensions, or to vacate the order. Now, also explain to both parties the maximum length of time and that you're entering the maximum length of time if they request it for the order, so that a minor does not have to relitigate the case later on using the same facts. So you want to ask the victim, how long would you like to have this order in place, and give them the maximum amount of time that is allowed when possible. If the petitioner and respondent have a child in common, that would be very situation in Wisconsin that I couldn't help them with, but there may be jurisdictions where you can consider custody, visitation, and child support. Just south of the border from me in Illinois, the courts can, in a protective order for adults and for teens, deal with the issue of custody, placement, visitation, and child support provisions to make sure those issues are dealt with so that people don't feel like they have to communicate about those issues, especially when there's an injunction in place.
Thanks, Judge Murray. And I'll just add that in D.C., you can request custody, visitation, and child support provisions in a protection order. And there are some judges who, well, I guess I would say the judges want to make sure that people aren't trying to use the domestic violence system to get the sort of family court orders that they want. But if they don't feel it's being abused in that way, they will readily order that as part of the protection order.
Yes, and I think it's just, having been a family court judge, I wish we had that power here in Wisconsin to deal with that issue, because it typically follows right after we issue the injunction. Someone's coming back to court to ask, well, then how do I deal with seeing my child, or how do I deal with getting funds to help raise my child? How do I deal with child support issues? So it seems to follow anyway. It would take more time during the hearings to deal with it, but I think those are issues that pop up anyway.
Yeah, and just to comment on one other thing that you mentioned about requesting the maximum length of time, I do think that's so essential in cases with young people, because to have to relitigate some of these issues and come back to court is as stressful as it is for an adult. It's even more stressful for young people and teenagers. So I think that's a really good thing to keep in mind, that you want to request the maximum length of time if that's what your client thinks is necessary to keep them safe.
Yeah, and perceptions of time for adults and children are very different, and how they perceive time. So any help in that area, I think, is appropriate by the courts and by the litigants, the lawyers and advocates who are working with victims of, teen victims of domestic violence. So, Marta, you have a couple of scenarios you want us to work with?
Yes, that would be great. So we're going to look at a scenario, the one that's on your screens now, and try to brainstorm together how to craft an effective proposed protection order if we were representing the survivor. So I'll just read through the scenario. Taylor and Jess are 16 years old. They dated off and on for about 2 years. Both parties attend the same high school. During the relationship, Jess physically abused Taylor. Taylor broke up with Jess 2 months ago. Since the breakup, Jess has been spreading rumors about Taylor at school, including a rumor that Taylor has an STI. Also, Jess has been showing up around Taylor unnecessarily, such as hanging out outside of Taylor's classes and sitting directly behind Taylor in the cafeteria. Taylor's worried that Jess may hurt Taylor. Taylor wants the rumors to stop and for Jess to leave Taylor alone. And I'll just mention that both the hypotheticals we're going to discuss today are based on case scenarios from Break the Cycle. And my questions are, if you were representing Taylor in a protection order case, what kind of provisions should you request in this case? And also, how would this protection order interact with Taylor's safety planning and Title IX rights? So if people can use the chat box to respond, that would be great. So the questions are, if you were representing Taylor in a CPO case, what provisions would you request? And how would that CPO interact with Taylor's safety planning and Title IX rights?
And from a judge's perspective, even if you didn't get a request, what provisions would you want to include in your protection order? This is your order. What would you want to do? And would this protection order interact with Taylor's safety planning? How would it do that? How would you look at it?
Right. Thanks, Judge Murray. Yeah, from the bench perspective as well, we'd really like to know about how you'd be thinking about these issues.
Screenshots. Yes, big problem these days, isn't it? Even for adults, even for older adults, folks.
I see a scheduling issue. That's a really good issue to note, because this is a school case where they're in the same school.
A lot of times people will come in and ask that that person be removed from that school. Sometimes that we've seen that either the school or the parents coming in. Have you seen that in your jurisdiction?
And then Ruth just wrote, including prohibition on mentioning Taylor on social media accounts. And that's a really good one, I think, because in the hypothetical, Jess has been spreading rumors about Taylor at school. If Jess is using social media to do that, the court could order that they not mention Taylor on social media.
Also, Catherine brought up the idea of informing the respondent that can't go through third parties either, which they tend to think they can, that they can get a friend to go and talk to Taylor. So Jess might think that that's appropriate. They need to let them know and be very specific about, hey, can't use third parties as well.
And then D. Stewart wrote, I would request the respondent be removed from the school. So that's definitely something that can be requested during Title IX proceedings with the school. We will sometimes advocate for that, advocate for a transfer, or we've had cases where the assault happened on school grounds, but the the respondent is no longer attending the school, and we've had the school ban that respondent from coming onto the school campus.
Good advice coming in from folks who are in the webinar, Marta.
Yep. Yep, those are all great responses. So for parties that attend the same school, which is really common in the cases we see with young people, it's important to include provisions in the protection order to eliminate or minimize contact at school and other locations where both parties must be present. So this would be in a case where you aren't able to, or until the respondent is transferred to another school, or if you aren't able to get the respondent moved to a different school, you need to really think creatively about what happens on that school campus. So for example, if the standard order says that respondent has to remain 100 feet or 100 yards away from petitioner, is that going to be possible in the school? Someone mentioned, I think, in the chat that the respondent should have to change their classes. That's when I was asking about how does that court order going to interact with Title IX. That's where you need to be thinking about taking that court order into the school and talking to the school about how they can ensure that that order is enforced and that that order is followed. So that means talking to the school about ensuring that there is no class overlap. Now, there may be situations where we had a case where the cafeteria was not even 100 feet wide or whatever was in the court order. So how do you deal with a situation like that? You have to ensure that they have different lunch periods. So you have to think about these very specific things. We've requested that schools put a buddy system in place for a client of ours where we knew it wasn't going to be possible for them never to pass each other in the hallways. Let's say our client has to go to the bathroom in the middle of the math class, and the respondent is going to the bathroom in the middle of his science class. They might have to pass in the hallway. So we've had the school implement a buddy system for our client. So really thinking creatively, referring the survivor to an advocate for help with safety planning, preferably before the order is entered, is also really important so the survivor can be really thinking about these issues and can make informed requests in court. And then reviewing Title IX in your jurisdiction, state statutes, municipal regulations, and local school district policies, so you can think about your case in the context of Title IX as well and the Title IX advocacy.
Yeah, Dave Stewart asked a good question. So what can be done in rural communities where there may be only one school option? And Stacy responded, there are some schools that offer online classes in those rural communities. Also, if you're in a rural community where there is only one school, having a school liaison person work with your courts might be very helpful. So when you have that case in court, you can bring the liaison in who works with, who's the liaison with the school. They can come in and understand what the situation is and what conditions need to be met by the respondent, and hopefully facilitate that discussion with the school. So having someone in your court system when you have these hearings probably be very beneficial.
Great. So we're going to examine another scenario and try to brainstorm together again about crafting an effective proposed protection order or drafting a protection order if you're a judge for this survivor. Imani and Mark are 15 years old. They dated for about 3 months. At the beginning of the relationship, Mark pressured Imani into posing for a nude photo that he took on his phone. During the relationship, Mark was physically and emotionally abusive, so Imani broke up with him. Mark became very upset when Imani ended things and sent the photo to some friends of his on Instagram. In the picture, Imani was nude and Mark put smiley face emojis over her private areas. Imani believes that Mark did this to avoid child pornography and non-consensual pornography charges. So if you're representing Imani in a protection order case or a judge in this matter, what kinds of provisions should be in the protection order? And again, how would that protection order interact with Imani's safety planning? So if you can use the chat box to respond with some of your ideas for the protection order and safety planning. So Mark's been has published this photo on social media of Imani, and she wants to prevent, she also wants to obviously be safe from further abuse, but her main issue is that she wants to Mark to stop doing this.
Well, maybe one of the things that the court can do is make sure that to inquire, and maybe through the help of an advocate, what pictures may be that Mark may have. Imani may have an idea of what's out there, and the court could order that all pictures be either removed from his computer or his phone. Hopefully, maybe Mark's parent is there, so that they can lock down the computer or phone so that he can't send pictures.
Right, and D says exclude the distribution of photos of the petitioner on social media, so prohibiting distribution of photos. Taylor says IG photo. What is IG? IG photo should be reported immediately. Once it is made known that she is a minor, they have a responsibility to remove the photo. Same goes for actual pornography websites.
So reporting to the...
Instagram. Sorry. IG, Instagram. Instagram photos should be reported, okay. So yeah, so cooperating, another order that you can request is that the respondent be ordered to cooperate with the takedown process. So we'll often help petitioners go through a takedown process with the social media platform, in this case Instagram, and the respondents can be ordered to cooperate with that process.
Right. I want the courts to understand that when you have that person in front of you, that respondent, that you can put a lot of restrictions on them and conditions, and set it over for a review hearing to see what's happening, what he has done to comply with your order. Mm-hmm. So review hearings are very helpful a lot of times in these types of cases to make sure that people are following the court order, especially when there are things that they have to do to make sure that certain things don't happen again.
And Terry has stated that order that Mark delete the pictures from his phone and direct that he not share them any further, which is exactly right. And Dee pointed out that, however, you have no idea whom all the photos have been shared with thus far. And this is the main problem with these cases, is that once a photo is shared, anyone can, even if it's been taken down from that social media, anyone who received the photo or saw the photo could have, of course, taken a screenshot of it. And so the photo is out there, and it is actually, as Dee points out, really difficult, if not impossible, to stop that photo from ever being shared again by anyone. All the court can help ensure is that Mark doesn't share any further, that he cooperates with any takedown efforts from the social media platform, and those types of things.
So, Marta, we've been focusing the past few moments on non-consensual porn. Are there other things that we should be concerned about when we're talking about customizing the protective order?
Yes, there are. So there's other ways you might want to customize the provision in a protection order, there's some examples here which include, but actually before I go over those, let's use the chat box for a minute to think about other things that may be specific to minors that you might want to request in a protection order. We've talked about some of these revenge porn cases.
What other issues show up, folks, in those protective orders that you are helping the victim get issued that you believe the court should pay attention to?
So as people type, I'll go over some examples. Minor clients, more often than adult clients, live with their families, and so it's important to consider including protective provisions for family members. In revenge porn cases that we've discussed, including provisions for takedown of the photographs and deletion of the images from the respondent's device. I think Judge Murray might have mentioned even having the court or the judge check the respondent's device to make sure that the images have been removed. And then, let's see what we have up in the chat box. Ruth said, sort out what should happen if they both show up at the same football game or other event. That's a great thing to think about, the places where their lives are going to overlap.
I agree. Being as specific as you can,
Mm-hmm.
and if you think about the lives of teens and what they do, is very different than, as you pointed out, Marta, than what adults do daily. So the opportunity for teens to interact are probably happens more often than it does for adults who may be involved in a domestic violence situation. So
Right.
That's a great idea, Ruth. Be specific, courts.
And then I also think that another thing we try to think about in teen dating violence cases that's I think people think about adult cases as well, but I think it's even more important in this context because we do know, because these are young people, and we know that they're going to go through a lifetime of relationships. I think it's even more important that we think about domestic violence intervention programs for respondents. And that can be tricky because in some jurisdictions, especially rural areas, it can be hard to find programs that will accept minors into those programs. But you should try to look for teen-specific domestic violence intervention programs if possible in your jurisdiction and not just a regular domestic violence intervention program. Or be creative about ways to have the abuser learn about healthy relationships. For example, writing a book report about dating violence and doing some research in the area. Having the abuser read materials from an advocacy organization like Break the Cycle or Futures Without Violence, Men Can Stop Rape, or Love is Respect. An additional option is to order the young person to contact the jurisdiction's Department of Behavioral or Mental Health and enroll in a domestic violence intervention program, an anger management program, or a sexual violence program. And to help with compliance and to give the survivor peace of mind, it's often a good idea to order the respondent to provide petitioner with some type of proof of enrollment or attendance, or to provide the court with that upon the completion of the program.
I think something else that judges who are leaders in their community and that are participating in their coordinated community response can make sure that the schools are at the table to have these discussions, because it very well could be helpful if the perpetrator is a sports advocate, or a sports person involved in the sports at schools. What do they offer these young men or young women in their sports, and when they talk about appropriate teen dating behavior? Mm-hmm. And so having the schools involved with a coordinated community response might be a good way of getting that idea out there, and because there are a lot of programs that are available online and through other programs about dealing with how young men need to respond to appropriately with young women.
And I just want to highlight Debbie and Sarah's responses, which I just read, because they're so spot on. Debbie Holler said if they ride the same school bus, alternate transportation needs to be arranged. Really good point. And then Sarah Hyde said, Audrey and Daisy is a great documentary about this, including non-consensual sharing of photos. Could be a good film to require youth to view and write a report on. We've also had youth read through the statement made by the young woman who was assaulted by Brock Turner and write an essay response. Those are really great and really creative ideas, exactly what we're talking about. There's a lot of other great documentaries and TV shows on the topic, and I'd be happy to provide people with a list that we have from Break the Cycle. And then Dee said, I know that we can order an offender to take safe dating classes when prosecuted, but what if we only have a PO and no prosecution?
And that's a great question, Day. You know what? If in your jurisdiction you're able to deal with the issues of custody, visitation, and child support, as a condition of someone having visits with their child, you can say, before I do that, I want you to start and at least or complete a domestic battery intervention program. So that can be a condition of them being able to see their child. It doesn't affect child support. It doesn't affect custody, but it could impact it right to have visits. So we don't have that in Wisconsin, unfortunately. So it'd be very hard for me to work with a young person in a protective order to get them to say, you know what, as a condition of the protective order, you should attend. I don't have that kind of power. I wish I did.
Okay, so I know we only have a few minutes left, so I'm going to skip safety planning. You all can just read that slide, and I'm sure you know what it is. But the one thing I wanted to say about safety planning that's sort of related to safety planning is that when you're interviewing your client is really determining whether they believe that part of their safety plan needs to include a legal remedy. And to distinguish what their needs and desires are and what they think will make them safest from what their parent may think is safest. This is a really unique issue in these cases where you may have a child, a young teenager and a parent coming in together, and the parent saying, my child was assaulted, she needs a protection order. You need to really be careful and interview the client alone. They're like adults. They know what happened in their case the best. They know what's going to keep them the safest, and we really need to listen to them when we're trying to decide whether a legal remedy should be part of their safety plan.
And just let me say amen, because we need to remember victim autonomy still is in play even for teens as it is for adults. So we need to listen to the victims as to what they think would keep them safe.
Great. So finally, sorry, my computer just went out. We just wanted to close with
The ethics?
The ethics, which we just discussed a little bit, but talking with minor clients may require you to comply with rules governing ethics and mandatory reporting. So mandatory reporting is another kind of unique issue when you're dealing with young people. So prior to potential young clients sharing information with you, it is important to let them know whether if you are a mandated reporter in your jurisdiction, that you are a mandated reporter. There's at the bottom of this slide, there is a link to a list of state mandatory reporting laws, so you can check and be sure under what circumstances you would need to report something and whether you are a mandatory reporter. And that's really important to know, to let your client know if you are. And then also if you do need to go through the reporting process, to explain that process before making the report to your client and involving your client at every stage of that process. So I'll just ask whether we have any final questions before Judge Murray wraps up. So if you have questions, please add them to your chat box. We have about 2 minutes for questions.
Sarah did ask one about, what do you do if the victim is being isolated by her parents and that child cannot get out to see an advocate, or they can't get to see her. I think in those cases, if the courts will allow it, I'm not sure how you might do this in your jurisdiction, but if you come in and ask for a person at risk, file an injunction on their behalf, and then ask that a guardian ad litem be appointed on behalf of that child, who can then do an investigation and have some authority to have access to that child, either to child's school or maybe another safe place where they can have a conversation with the child. I don't have very much more to offer, Sarah, than that. Any other questions? Not seeing any, let me just say thank you all for attending this webinar session on teen dating violence and protective orders. I remind you of the Institute on Teen Dating Violence, November 5th through the 8th, 2017, in Phoenix, Arizona. It's a great time to be in Phoenix. It's not as hot, but it will be a great presentation and institute for you to attend. We hope that you sign up for it. Martha, thank you for taking the time to spend with us and educate us. And I hope that everyone enjoyed the information and the presentation. We enjoyed being with you.
Hey, Judge Murray, I just wanted to interrupt for a second. This is Rebecca, and just remind everyone this is going to be specifically, the Institute will be specifically for judges only. So
Sorry about that.
That's okay. If you're an advocate, though, and you're on this, please please inform judges that you work with and tell them to please come to this. We'd love to have them.
And let us know if you're interested in coming to any other trainings, as we do have contacts with specifically for advocates, custody evaluators, that sort of thing. As we're wrapping up, I just want to let everyone know that there is an evaluation link just below the PowerPoint. If you would like a certificate of attendance, please click on that evaluation link, and at the bottom you can request one. Everyone will be directed there immediately after the webinar, and we'd love to know your thoughts. Thank you all for joining us.
Thank you, Marta. Thank you, Judge Murray.
Thank you. Bye-bye, everyone.
Thank you so much.